So,
Yes.
I'll move on to the second
appeal.
item on the agenda, the
Yeah.
Objection 1 merits appeal. Can I start, as I said I would earlier, with just providing the key points for this case in a nutshell. I'll then address you on legal principles, law in relation to unjust enrichment so far as it concerns this case, and then we'll get into the judgment and my criticisms of the judgment. So, in terms of our case in a nutshell, number of points. First, CFA 3 constituted an entire contract under which Rosenblatt was not entitled to payment for its services until it completed its services in acting as a solicitor for GHC in relation to its claim, and even then, only in the event that a win was achieved. Second, there's good authority to support the proposition that where an entire contract is prematurely terminated by the service provider as a result of his client's repudiatory breach, a claim in unjust enrichment will arise. Third, the reason why such a claim arises is that there has been a total failure of basis, to use modern terminology, in respect to the services rendered. We say that this isn't essential for our case, that the basis which has failed can properly be regarded as being that the service provider would not be unlawfully deprived of the opportunity of completing performance and earning his fee. Just pausing there, the reason why I say...
The provider would not be unlawfully
deprived. The reason why I say that that isn't necessarily an essential part of the case is if the case is where an entire contract has been prematurely terminated and an unjust enrichment claim has arisen, are not to be analysed on that basis, then on any view there has been a failure of basis in respect of the services that have been provided, because the contract has been terminated before the fee, before performance has been completed and the fee earned. But the rationalisation as to what that basis is that's failed is one that I adopt for the purposes of my argument on this appeal as the most likely candidate, and we'll see that there is analysis in Goff and Jones, which in the context of a decision of the High Court of Australia in Mann v Patterson, which is just an instance of a entire contract, or in that case actually a contract with a series of entire obligations where termination and the claim for what quantum merit on failure of basis has been suggested by the authors of Goff and Jones can be analysed in that way. So that's the third of the propositions that I put forward. Fourthly, in the event that CFA 3 had not contained clause 14, including clause 14.3, we say that it would be difficult for GEHC to argue that such a basis, the one I've just spelt out, could not be found to operate as the basis on which the services are provided. Indeed, I'll take you to paragraphs in their skeleton, 41 and 64, in due course, where they come very close to accepting that such a basis could be said to arise where you have an entire contract without any special provisions in it. And we say, in terms of the analysis, it is helpful to first analyse the position without clause 14 to see whether the implied basis can be, the underlying basis can be said to arise, and then to consider whether that position changes when you factor in clause 14. We say it doesn't. And that leads me to the fifth point. We say that the position is no different when one takes account of clause 14 and clause 14.3 in particular. That clause does not legislate for what will happen if termination takes place by Rosenblatt for repudiatory breach. So far as wrongful termination is concerned, it only
So it
addresses...
doesn't cover Rosenblatt's repudiatory breach.
It does not legislate for what will happen if termination takes place by Rosenblatt for repudiatory breach on the part of, I could have added the words, on part of GEHC. So far as wrongful termination is concerned, it only addresses what happens if Rosenblatt chooses to exercise its right to terminate under that provision rather than at common law, in which case Rosenblatt would be entitled only to payment of its basic charges, foregoing any claim that might take into account the prospects of a win, which would result in a 100% uplift. Sixth, as the judge noted in his judgment at paragraph 15, and I'll come to it just in just 1 second after I make this point, when commenting on clause 14.3, he said, doubtless the provision is only reluctantly triggered because the solicitor does not recover any uplift or success fee. I could just pick up, we might as well, because we're going to go to the judgment in just 1 second, so we might as well open it up at C Core Bundle 1 at tab 19. And paragraph 15, which I've just quoted, is at page 187. Where he makes the point I've just said. Now that, paragraph 15, now that potential loss of the uplift or success fee is particularly significant, whereas in this case, at the point of termination, a win in the proceedings had already been achieved, so long as, and it's an important caveat, the orders in GEHC's favour were not overturned on appeal. Sixthly, when looking at the judgment of Mr. Justice Smith, the most important paragraphs in my submission, and therefore central to the appeal on the merits, are paragraphs 53 to 55. So if we can just turn those up at page 195. In paragraph 53, the judge says that CFA 3 made detailed provision in anticipation of problems arising prior to the claims resolution in clause 14. He then says, in one sense, it was a complete code that anticipated a number of risk contingencies, and then he identifies what those are in Roman numerals 1 to 4. And then in paragraph 54, he acknowledges, as he must do, that in another sense, clause 14 is not a complete code, because of course the common law remedy of damages, he says, for repudiatory breach of contract remains in addition to clause 14. Had this common law remedy been excluded by the contract, then it's clear that a claim in unjust enrichment would not have been attainable. In my submission, it's not accurate to say that what clause 14 clause 14, including 14.3, does not do is exclude the remedy of damages for repudiatory breach. Clause 14.3, or the rest of clause 14, doesn't deal with termination for repudiatory breach at all. And of course, termination for repudiatory breach, we submit, may give rise to a claim in damages, but it may also alternatively give rise to a claim in quantum merit on the grounds of unjust enrichment. And the judge then says in paragraph 55 that the question is whether the existence of a choice for Rosenblatt to end CFA 3 by other means renders a restitutionary remedy possible. He says, in my judgment, it cannot, because CFA 3 has already articulated what is to happen in this case, see clause 14.3. And that is a major error with respect to the judge in his analysis, because clause 14.3 does not address termination for repudiatory breach. It only addresses contractual termination under that clause for breach, which was not a clause which was activated, triggered by Rosenblatt, who were entitled to take the view, as they did, that they would terminate at common law. So that then leads to the problems that we get in the balance of this paragraph, which is essentially the key reasons for dismissing the appeal. He said, the existence of the common law right in damages is not to open the way to an alternative restitutionary claim that is duplicative of clause 14.3. Well, first of all, restitutionary claim in quantum merit would be a valuation of the services that were provided. That would not, on our case, be duplicative of a damages claim for a variety of reasons. One is that, it would not be duplicative of clause 14.3 for the reason that we say that in valuing the services, account would need to be taken of the chances of success as at that stage, because that forms part of the objective valuation exercise of the services that were rendered to the client. And indeed, that is one of the points we'll see that is raised in my friend's skeleton when we get to it, that there is a potential difference in the valuation. And then we get to the crucial sentence, or part of a sentence. He says, that would be to upset the considered exercise in risk allocation expressly contained in CFA 3, dealing with precisely this case. And that's really the nub of the criticism we make of the judge, because clause 14.3 is not being triggered. We are dealing with repudiatory breach, which is not the subject of a provision in clause 14. There is no upset of the considered exercise in risk allocation in seeking to pursue a remedy, in this case quantum merit, on the basis of repudiatory breach. And we'll see, I hope, after I've taken you to the authorities, that this reference to risk allocation features really throughout the relatively short section of the judge's judgment on unjust enrichment, which starts at paragraph 41. It features there because the judge focuses on the authorities which were concerned with subsisting contracts and unjust enrichment claims in the context of those, rather than the focus, or in addition to that, the focus on ineffective contracts, in particular contracts which have been discharged on the grounds of repudiatory breach, and where the right to payment for performance under that contract has not arisen at the date of termination. So the language in terms of allocation of risk and the obligation rule, which is as defined in Dargamo, which we will, sure you're familiar with, but which we will come to, is in the context of particularly subsisting contracts. And the judge did not make a distinction, or a sufficient distinction, between subsisting contracts and discharged contracts for breach in his analysis. But in terms of the key points that we say where the judge went wrong, there are others. It's in this paragraph 55 for the reasons which I have just given. And it is a feature of this case that we presented to the judge authority in relation to termination of entire contracts, repudiatory breach, and entitlement to quantum merit claims. And those are set out in our skeleton, and I'll come to them briefly in a moment. And they aren't addressed by the judge at all. And that's because of, just helpful to have in mind that his focus has been on the subsisting contract cases and the analysis there, and then he's carried that through erroneously for the reasons that I've just given. So that was all under the context of the seventh point that I made, which was the critique of the judgment. The eighth point that I'd make, and the final point, is that this isn't a case where, to use the language in Dargamo, there is no space for an unjust enrichment claim. This claim does not override the express contractual regime, notwithstanding the views taken by the judge that apparently that did so, because he talks about upsetting the considered exercise in risk allocation. So those are our sort of main points in relation to our challenge to the judgment on unjust enrichment. Now, before I develop that further by reference to legal principles and then the judgment in a bit more detail, could I just sort of, having thought further about the point raised by my Lord Justice Stuart-Smith in relation to 14.1 of CFA 3, could I just return to that? I stand by my submission that whatever the answer, it doesn't impact the arguments we are advancing in the merits appeal, but having looked at it further, if I go to tab 22 of Core Bundle 2 at page 210, so the question that I was asked, just I'm sure no one's forgotten, is what's the position if there's a termination under 14.1 and there is no, the claim is continued and there is no win. And I'd said that it would appear to follow, even though it's not addressed in the clause, that there would be no fee payable because there's no win. Looking at it further, I don't think that is right. And the reason I don't think it's right is I've overlooked two words within the final sentence of 14.1 in my rush to respond to your question. Because 14.1, the final sentence says, if the client wins, continues with the claim and wins, the client will also have to pay. So it's the word also. And then it doesn't say we'll also have to pay the basic charges plus the success fee. It just says the success fee. and the success fee is the uplift element. That's defined on page 205. So it's not saying if that was a self-contained code of what you're entitled to, that you'd be entitled to the basic charges and the success fee. First point. And the second point is it is the word also. And I think in my submission,
I haven't quite followed that.
sorry.
Are you saying that if the client, having terminated the agreement, continues with the claim and loses, the client has to pay Rosenblatt's fees up to the date of termination?
I think that is one reading of the clause. And
What is the correct reading, do you say?
I would submit that is the correct reading of the clause.
Right, and where does that
Accepting that there is a lacuna in the wording, because it doesn't actually expressly address the
So
position.
what is this? Is an implied term?
Or one might regard it as implicit from the wording of the second sentence. So I'm not sure whether that would actually be an implied term or a point of construction, that having regard to the premise of considering the premise of the final sentence, which is suggesting that if you continue with the claim, they will also have to pay. So if you're continuing with the claim, what would you also be having to pay? It would be, I would suggest that it's assuming that the mere continuance of the claim would entitle you to your, at the point of termination, would entitle you to your base fees.
Up to the time of the conclusion of the case?
No, well, you wouldn't have incurred any more base fees up to the date after termination, because...
So what it should have said is, if the client does not continue with the claim, or continues with the claim and loses, the client must pay Rosenblatt's fees at the normal rates for works done to termination. If the client continues with the claim and wins, then he will also have to pay the base fee.
Yes, because otherwise, A, if that wasn't the case, you wouldn't have had the word also. But secondly, if that wasn't the case, then it would have actually needed to say the client will have to pay the Rosenblatt's fees plus the success fee for that work.
The fact that we're rewriting the clause as we go along, and it doesn't reflect your first reaction this morning, suggests that the drafting is less than perfect.
I agree.
So it's quite a stretch to impose everything on the word also.
Well, and the reference to success fees and not referring to Rosenblatt's fees as well. Rosenblatt's base charges as well.
Which brings also into effect is that the client continues with a claim and wins, and then also naturally refers back to Rosenblatt's fees at the normal rates. But the condition which triggers that also is if the client continues and wins. No other condition.
Yeah, but if the client continues with the claim, the second sentence of 14.1 is not dealing with the client continuing with the claim, the client not continuing with the claim. So the use of the word also have to pay is, I would suggest, not referring back to the obligation in the second sentence, because that's not even come into play.
I just simply don't follow that as a matter of English.
Well, I don't want to waste too much time on it, because maybe this point will be taken against me anyway in some way on the merits appeal, but I don't think it's relevant to the merits appeal. But I wanted to address a question that had been put.
The reason why it might be relevant, or the reason why I asked the question, is that your base submission is that there's nothing in the agreement that's inconsistent with the claim that you're now pursuing. And if this is an agreement which doesn't make provision for everything, that may have an effect upon your argument.
I don't know. I don't think whether or not clause 14 other than the point I'm making is a complete code or not, doesn't affect my argument. My argument is premised on the basis that there has been a termination of an entire agreement. There has been a failure of basis, and we say the failure of basis can be looked at on the basis, can be looked at by reference to not being unlawfully deprived of the opportunity to earn the fee, unlawfully being an important aspect of that. It's only if there was something in the agreement which cut across that basis, i.e., if the agreement had provided, for example, that in the event of termination for breach, howsoever caused, my entitlement would be X, then there would be no basis for an unjust enrichment claim, and you could view that on the basis that either such a clause amounts to an exclusion of any claims other than your claim for payment, or you could view it on the basis that provision negates the basis for which contention is being put forward, because it does contemplate that a termination for repudiatory breach will only lead to a limited, a set remedy. So I think that's a different exercise to the exercise which is undertaken in relation to silence and gaps in the contract in the context of the subsisting contract cases, such as for example, in Barton, which we'll come to, where what the court is considering is where services have been rendered under a contract, is that service one that's been rendered pursuant to a legal obligation. And what the court considers in those cases is whether there is, because of silence in the contract in relation to what will happen if, as a result of the provision of those services, a particular event occurs, that gives rise to the ability to make a claim for unjust enrichment. I was engaging in a different exercise there than the case of a termination of a contract leading to an unjust enrichment claim, where you're not looking.
Just explain why. Why should it be different? If you're looking at a post-termination claim of some sort, wouldn't you have to go back and look at the terms of the contract to see whether such a claim is maintainable?
Yes, I was dealing with the silence point. So where there's a gap in the contract.
I understand that, but silence is silence, whether you're looking at a contract which is the terms of a contract which has been terminated, or the terms of a contract which is still in being, or...
Well, I think in those in the circumstances of a termination for repudiatory breach, and the question of whether the claim in unjust enrichment is maintainable, the question that arises is whether the contract has made provision for what your remedy is going to be in the event of such termination. So you do look at the contract.
Yeah. So why is silence qualitatively different according to whether you're interpreting the contract before it terminates or after it's been terminated?
You're addressing a different question in the context of maybe I should wait till I get to the authorities on this, but in the context of a subsisting contract, such as Barton, what one is looking at is whether the whether the contract can be said, well, I'm going to put it a slightly different way. What one's looking at in the context of a case like Barton is whether Barton was a case where it was effectively a unilateral contract. If I find a purchaser at this price, a fee will be payable. So the question was, well, what happens if, as was the case, he found a purchaser, but it was for below that level? And so the question of silence comes in that context, because one is asking, did the parties anticipate that in the event that you provided a client to buy at below the relevant price, you would still be entitled to some form of payment? And the court looks at the contract in that context and says, well, the contract only provided that you would be entitled to X in the event that you got to price Y, and you can't, from the failure of the contract or the omission in the contract, if you want to call it that, to address what would happen if you came in at below that price, you can't deduce from that that there was any intention that you would be remunerated.
No, I understand all that, but what I'm puzzled about is why the exercise of interpretation differs according to whether the contract has or has not been terminated. Let us suppose that Rosenblatts take the view that Global Energy have committed repudiatory breaches of the contract, and Rosenblatt now has to decide, what are we going to do about it? Well, we could terminate under clause 14.3, or we could simply accept the repudiatory breach. We know that if we terminate under clause 14.3, we get our base costs to date and no more. What happens if we terminate for repudiatory breach? Well, we better look at the contract and see what, if anything, it says.
Yeah.
So there we're construing the contract before Rosenblatt have decided whether or not to trigger clause 14.3 or to accept the repudiatory breach. Why does the exercise in interpretation differ according to which choice they make?
Because it doesn't differ in terms of interpretation,
right?
But the purpose for which you are conducting the exercise is different in the two cases. So in the first case, what you are seeking to do is to ascertain whether there has been any unjust enrichment. So you are looking at services in the subsisting contract case. You're looking at the services that were provided, and you are determining whether or not that gives rise to unjust enrichment, which requires you to have regard to what the contract provides in terms of the obligation rule and the allocation of risk, and to arrive at your decision as to whether it's unjust. In the context of the terminated contract, the services have been provided on a basis which has failed, and for which no payment has been, no entitlement under the contract to payment has arisen. So if the position is that the contract does not provide by its terms for what you will be entitled to receive under in the event of termination for repudiatory breach, then you have failure of basis and unjust enrichment. If, however, you construe the contract to say, well, even in the case of repudiatory breach, it is provided that you will be entitled to this remedy, then your failure of basis argument falls away.
So there is no such thing as silence.
Sorry?
So there is no such thing as silence in the latter case, if there's termination, you're just saying if there's nothing in the contract, then inevitably there's a failure of basis. Whereas isn't one required to look at the contract as a whole, and that silence in the contract may also have some significance in relation to the allocation of risk?
Well, it may have some significance if when you come to construe the contract, and or maybe when you're looking at implied terms, the possible gap in the contract, which is what I call the silence, comes to be filled. So, I mean, if you're construing the contract and you say, well, actually, the contract provides either on a proper construction or by, a bit difficult to see how it would work, but by implied term, that even where you terminate for repudiatory breach, your entitlement is to the same amounts as you get under 14.3, then obviously my quantum merit claim would fail. But in those circumstances, I'd be entitled to the base charges. But that's not the case that's being advanced against me.
This is too complicated for me. Are you saying anything more than if the contract provides for what happens in the events that have occurred, then you follow the contract? And if it doesn't, you then have a question to decide whether on the proper construction of the contract, that means there's no entitlement to be paid, or on the proper interpretation of the contract, you've got a basis, a failure of basis claim. Is that what you're saying? Because if it isn't, it's too complicated for me.
You suggested that you might look at the contract to see whether the contract on its construction provides that you've got no entitlement to payment. Well, I mean,
But if this case is Barton, then arguably you've got no entitlement, as I understand the position. The alternative view is that notwithstanding Barton, the absence of a provision for what happens after acceptance of repudiatory breach doesn't preclude you recovering.
well, you'd still need to show unjust enrichment. Okay, point one. For the purpose of unjust enrichment, you would need to show that there had been a failure of basis in relation to the services that had been rendered that led to the identification of this purchaser. And in order to show that failure of basis, you would need to show, in my submission, that the services were provided on a basis which would result, if once the services were provided, in payment being received. Otherwise, there wouldn't have been a failure of basis. Or a state of affairs, or it was provided on the basis of a state of affairs. This would be the Barnes case, on the basis of a state of affairs which has failed to arise or failed to be maintained. And in the case of Barton, that just simply doesn't arise, because all you've got is this very simple unilateral contract, which says nothing about whether there would be any even anticipation of some form of payment if you did not meet the particular requirements of that contract. So it's not a case of failed counter-performance or anticipatory counter-performance by the defendant in the proceedings. It's just a very different case. I mean, if what you're coming down to is to say, well, you've got to construe the contract to determine whether or not the contract either provides for what would happen, what you would be entitled to on a common law termination, or that whether it excludes any claims where you terminate a common law, then well, I wouldn't disagree with that. Yeah, if you would look at the contract to see whether or not there are any such provisions, but it wasn't found by the judge that there was any such contractual provision, and it's not being advanced against me on the appeal that there is any such provision. So I'm not suggesting you don't have to look at the terms of the contract and construe them. Of course you do, because you're analysing the terms of the relationship between the parties. But one comes back down to the very, really the very short point that the judge in his judgment said that CFA 3 has articulated exactly what's to happen in this kind of case, clause 14.3, and it doesn't. Clause 14.3 is articulating what happens where you terminate pursuant to clause 14.3, and the whole reason we're here is because there is no termination pursuant to clause 14.3, and we are outside of that.
Well, that's interpreting the judge's words very literally, isn't it? What he I think means is that clause 14.3 deals with a case in which the client does not meet its responsibilities.
Yes.
That's what he means. That's the situation which clause 14 is clause 14.3 is contemplating. I don't think he's saying that. I don't think he should be taken as saying that clause 14.3 embraces the situation where Rosenblatt does not exercise clause 14.3. That would just be a contradiction in terms.
Well, but he then goes on to say that an alternative restitutionary claim would upset the considered exercise in risk allocation expressly contained in CFA 3.
But what he means is Rosenblatt has a remedy in the event that the client does not meet its responsibilities, and that remedy is to terminate under clause 14.3. That's what he means.
Well, it's not in pursuing a restitutionary claim, unjust enrichment claim, consequent on termination for repudiatory breach. Rosenblatt is not upsetting the risk allocation contained in CFA 3. It's CFA 3 in terms of clause 14, which I assume is what he was referring to, provides for certain instances of termination, and it provides for one instance of termination for breach, or one specific instance, but that isn't where we've gone. We're not under 14.3, so how can it be said that the exercise of this right and the pursuit of this remedy, either or both, is upsetting the risk allocation? And that appears to be fundamental to his decision. So, if I may just develop that's a little bit further. In relation to the law, can I take you to some of the authorities? What I've tried to do is to distill from the cases that we have advanced some principles which I think logically may not be controversial, but we'll wait and see. Particularly in relation to claims for unjust enrichment arising out of contractual relations. So if I can vocalise those principles, and there are 8, and then I'll take you to the authorities, and what I'm going to do is take you to the commentaries first, and then some cases on subsisting contracts, and then the cases which the judge does not deal with at least expressly in his judgment, on terminated contracts for breach. So first of all, we say that where a benefit has been transferred, I should say I'm taking it as read that we have the 4 questions. Has the defendant been enriched? Was the enrichment at defendant's expense? Was the enrichment unjust? And are there any defences? And I'm really concentrating on the unjust enrichment element. So first of all, where a benefit has been transferred pursuant to a contract which remains open or been discharged by performance, no claim in unjust enrichment would generally lie. The principle is based on the fundamental premise that the law should give effect to the parties' own allocations of risk and valuations as expressed in the contract, and should not permit the law of unjust enrichment to be used to overturn those allocations.
Are you quoting from your skeleton? Because if not, I think you need to go a little bit more slowly so I can write.
Okay, I'm not quoting directly from my skeleton, so
Right.
I said I tried to bring
Where
this
a
together.
benefit has been transferred pursuant to a contract discharged by performance, no restitutionary claim arises.
I'll start again. Where a benefit has been transferred pursuant to contract which remains open,
By which you mean
by which I mean it's a subsisting contract still in the course of performance.
Yeah.
Or has been discharged by performance, so completed. No claim in unjust enrichment will generally lie. And then said the principle is based on the fundamental premise that the law should give effect to the parties' own allocations of risks and valuations as expressed in the contract, and should not permit the law of unjust enrichment to be used to overturn those allocations or valuations. And I'll take you to both Goff and Jones and McDonald and Costello, which is an example of that.
yes.
Secondly, the enrichment will be unjust where there is a failure of basis, though that's not the only case where there is unjust enrichment. And on that, I say, still part of the second point, the core concept of failure of basis is that a benefit has been conferred on a joint understanding that the recipient's right to retain the benefit is conditional.
Sorry, the core concept of failure of basis is
Joint understanding the recipient's right to retain the benefit which has been conferred on him is conditional. And that's, I'll take you to Dargamo on that. Thirdly, the basis of transfer must be jointly understood as such by the parties and is ascertained objectively by reference to the nature and terms of the contract and the circumstances of the case.
Please would you repeat that? Basis
Yeah.
of the transfer must be understood by the parties.
Must be jointly understood as such by the parties.
Well, how is that compatible with the second part of your submission, which is to be objectively ascertained from the terms of the transfer? Doesn't matter what the parties subjectively understood, does it?
Their joint understanding is ascertained objectively by reference to the nature and terms of the contract.
So
Just the same way
their
as-
understanding doesn't really matter. You could cut that bit out of
I could do.
the proposition. Yeah.
I could do. Fourthly, an unjust factor will not override a valid and subsisting legal obligation of the claimant to confer the benefit on the defendant. That's the obligation rule in Dargamo.
Would you repeat that again? An
Yeah.
unjust factor does not override.
Will not override a valid and subsisting legal obligation of the claimant to confer the benefit on the defendant, and that is the obligation rule as defined in Dargamo. And that is why we say unjust enrichment claims will generally fail in respect of subsisting contracts, which I mean contracts which are ongoing, or indeed contracts which have been performed, where the benefit has been provided in accordance with the terms of the contract. And put another way, there is generally no space for an unjust enrichment claim where a benefit has been transferred pursuant to an effective contract, a subsisting contract, or one that's been fully performed. The fifth point, where a contract is terminated for repudiatory breach, a claim in unjust enrichment may be available depending on the facts of the case. And we would say, just by amplification of that, that a distinction would fall to be made between a case where the innocent party who's provided the services under the contract has accrued a right under the contract for payment by the date of termination for those services, and a case where no unconditional right to payment is accrued. In the first case, the accrued right will generally prevent the claim for unjust enrichment because the claimants receive what he contracted for, whereas in the case where he's not had any accrued right, a claim in unjust enrichment may be available. Sixthly, where a party enters into a contract under which he agrees to undertake an entire obligation in return for payment, no payment is due unless and until he completes performance. That's pretty unexceptionable. There are some glosses on that which suggest where you've completed substantial performance, that may be sufficient, but we don't need to worry about that. Seventhly, the reason for the party being unable to complete performance of the duties it owes under an entire obligation is that it has accepted a repudiatory breach committed by the other contracting party. A claim in unjust enrichment is not denied. And we say that that principle is the explanation for a number of cases where unjust enrichment has been allowed in such circumstances. And finally, a contract may expressly exclude or limit a claim for unjust enrichment. Again, I don't think that's controversial. So in relation to those propositions, if I could take you to Goff and Jones and Chitty first of all, before I take you to the case law. If I could start with Goff and Jones, so if we can, if I can invite you to go to the Authorities Bundle, Volume 3, tab 23. And if I can ask you to turn to page 641. I should explain the way that we've had to print this out is that the supplement, the paragraph, replacement paragraphs only appear in the supplement. So you lose the context of where it appears. So could I just for your reference, if you just turn back to page 624, you'll see there the old paragraph 3-12, and it's that short paragraph that's been replaced by the long paragraph we got on page 641. And can I just invite you to read that paragraph to yourselves?
The one at 641.
At 641, yes. And the part I particularly wanted to emphasise is about 6 lines down, where they say that we suggest that the terminology of an obligation rule needs to be approached with great caution, because it does not give an adequate indication of the relevant legal principles, over-inclusive, under-inclusive, and potentially inaccurate. And then they say it's over-inclusive because where a benefit has been transferred pursuant to a contractual obligation and the contract has subsequently been terminated or rescinded, there is no automatic bar to a claim in unjust enrichment. In other words, the rule only applies to obligations under subsisting contracts and contracts discharged by performance. And that reflects that there is a difference of analysis when it comes to the details of unjust enrichment, where you're dealing with a subsisting contract case and where you're dealing with a contract that's been brought to an end for a repudiatory breach. And then we go back to page 625. This is under the heading Contracts Terminated for Breach. That's paragraph 3-15. They make reference there to the need to distinguish between benefits in respect of which no unconditional right to payment has accrued and those to which a right has accrued. The accrued right to payment survives the termination, remains the sole course, recourse available to the claimant, and then there's reference made to the Australian decision of the Australian High Court in Mann v. Paterson Constructions, and they say although the decision is not binding on English courts, its logic is compelling. And then they refer to Mr. Justice Gagler, and you can see the passage that is cited there. And then at the very bottom of the page, they say in respect to benefits where there is no unconditional accrued right, by contrast, over the page, the claimant can choose between claiming in unjust enrichment or for breach of contract. More on the discussion about that case in a moment. And then if we go to page 627, you'll see that there is a paragraph, scope of the contractual allocation of risk principle. And for that, I need to take you, I'm afraid, again to a replacement paragraph, which is at 643. And again, we're into the subsisting contract territory, and it's only the first three lines that really matter, since the underlying explanation for the principle that there's no claim in unjust enrichment where the contract is still subsisting is that the contractual allocation of risk must be respected. An important consequence follows: claims in unjust enrichment are permitted even where a contract is still subsisting, if those claims reflect the contractual allocation of risks. So when one is looking at the subsisting contract and whether it is one of those rare cases where a unjust enrichment claim does arise, one is asking the question as to whether the claim that is being made reflects the contractual allocations of risks. And then at page 646, paragraph 3, this is in the supplement 331 under implicit displacement of unjust enrichment by entire obligations. There's a reference beginning that terms of contract will frequently provide for payment to be due only once specified conditions are satisfied. Where the conditions are not satisfied, party who's done work or incurred expense in some other way in a failed attempt to complete the contractual performance is not permitted to have recourse to a claim in unjust enrichment. And then there's reference to Lady Rose in the majority in Barton, where parties stipulate in their contract the circumstances that must occur in order to impose a legal obligation on one party to pay, they necessarily exclude an obligation to pay in the absence of those circumstances. There's an obligation to pay under the contract and any obligation to pay to avoid the enrichment they received. Both any obligation to pay and any obligation to avoid an enrichment they received from being unjust. And then there's reference to Cutter and Power and Sumpter and Hedges, and then on the next page at 3-33, there's reference to the facts in Barton, the Supreme Court's fourth line held by a majority that both the claiming contract and unjust enrichment failed as a matter of contract. No term as to payment in the event of a sale at less than 6.5 million could be implied either in fact or in law. The contract therefore was similar in its structure to the contract in Cutter and Powell, where it was an entire contract. It wasn't terminated, but performance was not rendered in the way which entitled any payment to be made. And then there's reference to Lord Leggatt in the minority, but agreeing with the majority's position on unjust enrichment. If he had found that there was no implied term as a matter of law, that was in relation to payment for getting a purchaser at a lower price, he would have rejected the claim on the ground there is no room for an unjust enrichment claim where there is a subsisting contract between the parties. First, a party cannot be said to have been unjustly enriched by the receipt of a benefit to which she or he was legally entitled. Put another way, the existence of the contractual or other legal obligation to confer the benefit necessarily means the enrichment at the claimant's expense is not unjust. And then he said it would undercut the allocation of the risk in the contract to give an award for unjust enrichment. And then at page 636, we come back to the discussion about Mann and Peterson. So where the reason for the party being unable to complete performance is that he's accepted a repudiatory breach, a claim in unjust enrichment is not denied.
Right.
Sorry, 338, paragraph 338 on page 636.
Thank you very much.
And then it refers to an article of David Winston and Timothy Pilkington suggest the best explanation for this exception to the general rule that no claim in unjust enrichment is available in respect of performance falling short of the contractual specification is that the basis on which the contracting party commences in performance is implicitly that the other party will not unlawfully deprive him of the opportunity of completing that performance. The counterparty's repudiatory breach therefore causes the basis to fail. Thus, in Mann v. Peterson, a claim for unjust enrichment to a builder in respect of stages of work which he had not progressed far enough to satisfy the requirements for payment under the building contract, where the reason for the work having ceased was that the client had repudiated the contract and excluded the builder from the site. So Winterton and Pilkington also persuasively argue, since the agreed basis in such situations is that the contracting party will not be deprived of the opportunity of completing performance, a repudiatory breach which does not prevent completion of performance would not come within the exception to the rule. The innocent party in such a case can affirm the contract, complete performance and claim remuneration. And then in the other commentary I wanted to take you to more briefly is Chitty, chapter 33. So that is at tab 24 of this bundle. And the relevant chapter on restitution is at 671, Professor Virgo. And if I can ask you to turn to page 676. Paragraph 33018. We have discussion of Barton and of the Costello case in the context of the heading unjust enrichment, usually subordinate to the contract. So the first sentence, again, is dealing with where the relationship subsists between the parties, the contractual regime will usually prevail. Then there is a reference to the Barton case, and 3 lines from the end of that page, the sentence starts, crucially, the contract subsisted, it provided a complete statement as to when Barton would be remunerated, and this excluded a claim from being brought for unjust enrichment. The subsidiary of unjust enrichment rule provided significant. The subsidiary of the unjust enrichment rule provided significant. I think that should be proved significant in McDonald, Dickens, and Macklin v. Costello. So that was a case where the claimant had provided services to construct a development, and the contracting party was a company. The company was owned by individuals who owned the land and therefore, in that sense, benefited from the construction. The development was built, payment was not made by the company, and the claimant sought to bring an unjust enrichment claim against the owners of the land on the basis that they had benefited from his services and that it was unjust enrichment. And what's said there is that because the award for a restitution remedy, this is 4 lines down on page 677, would undermine the contractual arrangement between the claimant and the company, even though there was no such contract between the claimants and the defendants. And then it says it's however been recognised that whilst the general rule is there can be no claim in unjust enrichment where there is a subsisting contract, that's not an absolute rule, and exceptionally a claim in unjust enrichment may still lie despite the contract subsisting, as long as the claim is not inconsistent with the contract, particularly the contractual allocation of risk. And then in relation to discharge contracts, if I can I'll just have a moment. Yeah, contracts terminated for breach. Can I go to page 696? And there's a reference there made to Baron Alderson in
This is a 33080.
33-080, yes, thank you. Quantum merit for work done where the contract's terminated by breach, where one party is absolute, and this is Baron Alderson, this is said to be in De Benedi and Harding, where one party absolutely refused to perform, has rendered himself incapable of performing his part of the contract, puts in the power of the other party either to sue for breach of it, rescind, and sue on a quantum merit for the work actually done. Then they say such a quantum merit claim operates within unjust enrichment and is grounded on failure of basis. And then Planchet and Coburn, defendants engaged Planchet to write a volume for publication in a journal. He'd written some of the work, the defendants abandoned the whole publication, so he hadn't completed performance and he was able to recover reasonable remuneration. Then there's reference made to Prickett and Badger, and then there is a reference at 33-081 to a decision of Mr. Justice Cook in Taylor v. Motability Finance, to which reference was made by the judge in his judgment in passing. Could I just invite you to, this is the last passage I'll take you to in the in Chitty's. Could I just invite you to read that? Quite a long paragraph. 33-081.
Thank you.
Quantum merit and contractual remedies. You'll see there's reference there also to in this section to Ellick and Bartor, which I'll be taking you to in a moment.
Does your argument necessarily mean that Howes, Percival and Page is wrong?
Sorry, let me just go back to that. On the word, on the, it's quite a while since I went back to look at that case.
Well, from the summary,
The summary, it would appear that it would be
it
wrong.
rather looks as though it's on very similar facts to our case.
I think in front of the senior cost judge, you said it was per incuriam.
Sorry.
Just reminding you that I think it was
Yeah.
the senior cost judge refers to it, and you said it was per incuriam.
Yes. Yes, on the summary, that would appear to be right. I need to just remind myself a little bit about it. It did feature in the context of the arguments about the Buxton principle, as we put it, the decision of the Court of Appeal in Buxton before the senior cost judge.
Yeah.
And where we
there are three levels, so to speak, aren't there? There's what you might call a plain vanilla entire agreement case. Then there's an entire agreement which is also contingent on some other external event, and then there's the case where that entire contract has been terminated.
yes, I mean those are three different situations. The reliance that was placed on by the Judge Berens in Howes and Percival was that he placed on Taylor and Motability, which is obviously analysed here, where it was a case where the contract had been performed or substantially performed according to this summary, is obviously not the facts of our case. We were some way from completing performance of the contract. And it may be something I need to have a think about and go back to the case and very briefly address you on it tomorrow morning before my learned friend starts. So I can sort of properly answer my Lord's question, but by reference to the summary, that would appear to be the case. The court wasn't referred in Howes Percival to the Buxton decision, and one of the points that we raised in front of the senior cost judge was that it was
Buxton wasn't the case of a contingent entire
it wasn't
agreement,
I accept
whereas
that.
Howes Percival seems to be.
Yes. But you'll see the distinction that's made when we get to in the context of Taylor and Motability. You'll see the distinction that's made in the elegant Bartor decision of David Donaldson in a moment when we get to the cases concerning terminated contracts. So what I wanted to take you to now is actually some cases which are discussing these principles, and I'm going to start with the decision of the Court of Appeal in Dargabo, which is at tab 17, Authorities Bundle 2, column 2, at page 428. Decision of this court in which Lady Justice Carr, as she then was, gave the lead judgment and my Lady Justice Asplin and Sir Timothy Lloyd gave concurring judgments. And this is a subsisting contract case. Under which, and the claim essentially concerned provisions in the contract which provided for payment of total consideration of $950 million. The Taruta parties argued that of this amount, 82.5 million was paid on the understanding that the parties would enter into a further contract which never transpired. Therefore, they argued unjust enrichment, and there was in that case no reference to this further obligation in the contract, where the consideration to be provided in return for the 950 million was spelt out, and the claim, therefore, unsurprisingly, perhaps, failed. And in the judgment of Lady Justice Carr, she starts discussion, consideration of the law on just enrichment, at page 442 of the bundle, paragraph 51. Paragraph 55, she identifies the well-known 4 elements. And then at paragraph 57 on page 443, third question, the claimant must positively identify what has been described as the unjust factor. And then on the next page, paragraph 62, the need to identify and establish unjust facts was highlighted by Lord Toulson and Barnes. The unjust element in unjust enrichment is a generalisation of all the factors which the law recognises as calling for restitution after the citations. In other words, unjust enrichment is not an abstract moral principle to which the court must refer when deciding cases. It's an organising concept. The groups decided cases on the basis they share a set of common features, namely in all of them the defendant has been enriched by the receipt of a benefit gained at the claimant's expense, circumstances the law deems to be unjust. The reasons the courts have held the enrichment to be unjust vary from one set of cases to another. And the analogy that's drawn there is with the law of tort. And then at paragraph, next page, 65 and following, we have a section which deals with the interplay between contract and unjust enrichment. And she starts the discussion by saying that the relationship is has been and continues to be problematic. And it says that the two play distinct but complementary roles in the private law of obligations. And then 66, it was thought at one time a prerequisite to a claim in unjust enrichment was that any relevant contract must, if initially valid, have been discharged for breach or frustration, or be void, unenforceable or incomplete. This may have been a consequence of the fact that in almost all cases where the claimant seeks restitution for a failure of basis, any relevant contract will be ineffective. And where a contract has been discharged for repudiatory breach or frustration, the legal enforceability of the contract and the failure of basis are two sides of the same coin. And that's why I do place emphasis on that as distinguishing cases where the failure of basis arises on a contract that has been ineffective, where the services provided have been provided under an ineffective contract, ineffective where, for example, it's been terminated for breach, and cases where the services have been provided under a contract which is effective, in the sense that it's either still subsisting and open, or it has been fully performed. And in paragraph 67, she then says, as demonstrated by Roxburgh, invalidity of a relevant contract is not a necessary prerequisite to a successful claim in unjust enrichment. That's not to say that claims must not respect contractual regimes, the allocation of a risk between the parties. And then she quotes from Professor Burrows that an unjust factor does not normally override a legal obligation of the claimant to confer benefit on the defendant. The existence of the legal obligation means that the unjust factor is nullified, so that the enhancement at the claimant's expense is not justified. So one can just see, just pausing there, one can see how that operates on the facts of this case, where Taruta parties were under an obligation to make the payment of the 950 million, including the element that they said was paid on a basis that there would be a new contract, because that was its contractual obligations under the contract. No space for unjust enrichment. And then at 70, I describe a principle, namely that an unjust factor will not override a valid and subsisting legal obligation of the claimant to confer the benefit on the defendant as the obligation rule. And then
that's the phrase that Goff and Jones don't like very much.
Sorry?
That's the phrase that Goff and Jones don't like very much.
Well, I think that what they say in relation to that is, I mean, the point that I was referring to on that was that the obligation rule doesn't have an application in the context of ineffective contracts. And I don't think that bit is, it's just not qualified here in any way. It's just referred to as the obligation rule. And it's fundamental that a payment cannot amount to an enrichment. This is the citation from Lord Sumption and Briggs in DD Growth Premium, that a payment cannot amount to enrichment if it was made for full consideration. It cannot be unjust to receive or retain it if it was made in satisfaction of a legal right. And then the judge then goes on to deal with potential exceptions to the obligation rule. At paragraph 70, it's not absolute. There will be exceptions, albeit limited.
Sorry, you were at 70. Where have you gone? Where have you gone?
Sorry, paragraph 72.
Thank you.
Sorry. It's not absolute. There will be exceptions. Rationale behind these exceptions difficult to pinpoint. And then in the restatement, there was the suggestion for one rationalisation. You can see that's quoted at the end of 72. And then in 73, the law of restitution indicates the exceptions could be rationalised as follows: on the basis there may be no undermining of the risks undertaken by the parties, and so no inconsistency between the contract and the unjust enrichment, and the very need to establish failure of consideration is sufficient to prevent unwarranted subversion of the contract. Because if all parties had known the consideration would fail, the benefit would never have been conferred. So again, this is all in the context of discussion about exceptions to the obligation rule, and this is all in the context of subsisting contracts. And then in 74, reference to an article of Professor Burke's. It would be a very rare case in which failure consideration could be made out despite the existence and performance of a valid contract. And then over the page, paragraph 76, reference to my Lady Justice Asplin may have expressed the true meaning of the phrase gap filling. Sorry, that's a reference to the previous the citation just above, a reference to gaps. Only ever a gap if one concludes there should be a restitutionary claim. Lady Justice may have expressed the true meaning of the phrase gap filling with the greatest clarity during the course of the hearing. It's not gap filling in the sense of seniority or minority or being junior. It is because there's no space for the law of unjust enrichment in particular cases. In this way, the law of unjust enrichment can be seen as complementary. They're not subsidiary to the law of contract. And that's why in the course of my submissions and one of the propositions I put to you, I use the terminology no gap for unjust enrichment. It isn't a case where there is no gap. Our case, it isn't a case where there is no gap for an unjust enrichment claim. And then finally, I want to take you to the section that follows now on failure of basis, which starts at paragraph 77. First of all, the reference to it's generally accepted in 77 that terminology failure of consideration is apt to lead to confusion. So that's then the preference in 78 is to adopt the terminology of failure of basis. And then 79, the core concept of failure of basis is that a benefit has been conferred on a joint understanding that the recipient's right to retain is conditional. If the condition is not fulfilled, the recipient must return the benefit, whilst failure of basis whilst failure of basis ranks alongside the unjust factors of mistake, duress and undue influence as a factor negative in consent. It differs in that it's concerned with the qualification of consent as opposed to impaired or vitiated consent. So that was my reference in my submissions to a benefit that's been conferred on a joint understanding.
So can we just translate that to the facts of this case? You say, do you, that Global Energy must be taken to have understood that the benefit conferred on it by Rosenblatt's conduct of the litigation was conditional on what? Rosenblatt's continuing to act as the solicitors?
No, the way I put it in terms of
on Global Energy's compliance with its own obligations?
That it would, that's getting close to it, that it was, that services were being provided to it on the basis that Global would not unlawfully prevent Rosenblatt from completing performance to give rise to a right or potential rights to a fee. In just the same way as...
So, I'll just write that down.
Yeah.
If you say that again, actually, on the basis that services were provided, on the basis that Global would not unlawfully prevent the performance of the contract.
By my client.
Yeah.
And that's because until my client performs, he's not going to be entitled to any...
And prevent them, therefore, to
Yes.
get into a position of the right to a fee.
Depriving him the opportunity to complete performance and earn his fee.
Mm-hmm.
Now, I may have slightly misquoted you, but this is what I've written down. Tell me where I've gone wrong.
Okay.
The services were provided on the understanding that the benefit constituted by those services was conditional on Global Energy not unlawfully preventing Rosenblatt from performing the entire contract.
No, that's not the, sorry, no.
That's not it.
No, let me just, can I just repeat what I said in my opening remarks this afternoon on this? We say that there has been a total failure of basis because the services were provided on the basis that my client would not be unlawfully deprived of the opportunity of completing performance and earning his fee. That's the basis which has failed.
Just said, but not obviously not.
But it's just, I didn't actually say that the reference to condition.
Well, I've taken it from paragraph 79 of Dargamo, and I was asking you to translate the core concept onto the facts of this case. And the core concept, says Lady Justice Carr, is that the benefits be conferred on a joint understanding that the recipient's right to retain it is conditional. So I was asking you what the condition was in this case on the facts.
Right.
And I understood you to say that the condition was that Global Energy would not unlawfully prevent Rosenblatt from doing something. Now, since it is an entire contract, presumably that something must be performance of the entire contract.
Yeah, the reason that I'm slightly balking is that I'm trying to articulate the basis and the failure of basis, and I'm not saying that that is a condition of the contract. What I'm saying is that it is the basis upon which services are being provided, and it's where those services where that basis has failed that you get the unjust enrichment. So what I'm saying is, if you look at the terms of the contract, the nature of the contract and its structure, as in other cases of entire obligations agreements where there is where services are being provided, the underlying basis is that the claimant will not be unlawfully prevented from will not be unlawfully deprived of the opportunity of completing performance and earning his fees. Now,
and so to translate that into paragraph 79, the condition presumably would be that one is allowed to complete performance.
well, I think the way I would the way that I'd put it is in the way I have, which is consistent with actually the discussion in Goff and Jones that I took you to earlier. So one looks at was there on what basis are the services provided? Has there been a failure? And then that gives rise to an unjust enrichment claim. I'm not particularly enamoured with the use of the word condition in that context, but what one can see is that if you render services under a contract which has become ineffective because of breach, so that you don't earn your fee, that the provision of those services clearly has involved some failure of basis, because you provided the services on the basis that you're not going to be unlawfully prevented from completing, and that's exactly what's happened.
What's the problem with the word condition? You perform the services on condition that you won't be prevented from completing your performance, or you perform the services on the basis that you won't be prevented. What's the difference? I don't know why you're allergic to the word condition.
Well, I don't. In some views, using the word elevating something to a condition might be viewed as quite a high bar, and I don't need to get there. If the term condition is being used in a loose term, as opposed to,
I don't think it's being used as a technical term to describe the importance of a contractual term. I don't think that's what Lady Justice Carmen to talk.
yes. Yeah, well, I mean, maybe we come to the same point then, in terms of my my submissions, because if it's provided on an underlying basis as I have described, then another way of putting that is that it's subject to not being unlawfully deprived, and that could equate to a condition. So it may just be a matter of semantics.
Well, we would be in good company if we adopted the Lady Chief Justice's loose language in this particular case.
You certainly would be in good company. I don't think I could disagree with that. Yes, yeah, I can't really disagree with that, and I'm not sure it really makes much difference to my underlying submissions. But I do also refer to the fact that in paragraph 80, the meaning of failure of basis extends beyond failure of a permissive condition or failure of contractual counter-performance, and includes state of affairs contemplated as the basis or reason for the payment has failed to materialise, or if it did exist, has failed to sustain itself. So it has potentially it can arise failure basis on a variety of circumstances, and certainly not limited to failures of promise, counter performance or condition. Maybe just in relation, before I proceed with the authorities, I can see the time already, so I'm going to have to turn fairly quickly to the judgment. But could I just pick up in relation to this, the question of the underlying basis argument, what is said in my friend's skeleton? So I did advert in the in my introduction that there were paragraphs where he appeared close to accepting that the basis for which I'm contending might well arise in the circumstances of a simple entire retainer. And my sort of analysis is, let's look at it without clause 14 and then see how clause 14 affects the position, if at all. So if I could just pick up his skeleton, it's core bundle tab 15. First of all, page 163. And first of all, paragraph 41. This is paragraph 39 has got my reference to my skeleton, which in turn refers to the discussion in Goff and Jones. And then at 41, GHC does not suggest the basis suggested by Winston and Pickleton cannot be applied in cases where the claimant is performing under an entire agreement in a relatively simple agreement. An officious bystander would think that it would go without saying that the performance is conditional on the claimant having the opportunity to earn the price. If they cannot, the benefit conferred must be returned. And then he says that's why a simple entire retainer, a solicitor who terminates a simple entire retainer early on proper grounds does not forgo any fee. And then at paragraph 64, this is at page 168, this is in the context of our criticism that the judge ignored the various authorities we cited to him, in particular Lusty, Blanche and Mann and Patterson and Ellick. The simple fact, 64, is that these cases were not relevant to the question for the judge beyond demonstrating the potential for implication of an implied basis along the lines suggested by Winston and Pilkington. That such a basis might be implied in an entire agreement was and is common ground. None of the authorities relies upon, however, establish that such a basis will be implied, always implied, or can be implied in the face of the express terms of the contract, which legislate for very different events. And that's where we get into the argument about the impact of clause 14.3 on the analysis. So I wouldn't go as far as say there's common ground, but there's some almost meeting in relation to the simple retainers. I'm not going to take you to the decision in McDonald and Costello. I've already told you what the facts of that case are, and the basis of the decision, which was that you had a contractual regime which provided that your source of payment as builder for the work would be the company, and there's no room for an unjust enrichment claim. In the case of Barnes, this is a decision of the Supreme Court. If I can take you briefly to that, it's at tab 14 of the bundle of authorities, so that must be at the end of volume 1. This is a case of a contract between the CPS and a receiver to be appointed over a receiver in respect of a company on the basis that the receiver would have recourse to the assets of the company for payment. The validity of the appointment as receiver over the company was challenged, and it was held to be invalid. He lost therefore the security that he would have expected over the company's assets, and brought a claim, various claims, and one that succeeded was against the CPS in relation to failure of basis. The failure of basis being that he didn't have the state of affairs he expected, which was recourse to the company's assets, did not, in the event, materialise. And just the only point I want to take you to in relation to that is at page 309, paragraph 108, so 106 in the judgment of Lord Toulson, and that's simply to make the point that says failure basis or failure consideration does not necessarily mean required failure of a promised counter performance. It can consist of the failure of a state of affairs on which the agreement was premised. And then at 108, he says the receiver has lost his lien. Professor Burke's reference to the failure of consideration for a payment, that's the passage we can see just above, would apply equally to failure of consideration for the provision of services. And the passage above says failure of the consideration for payment means the state of affairs contemplated as the basis or reason for the payment has failed to materialise, or if it did exist, has failed to sustain itself. So there were a line of, I think that's all I want to say in relation to the cases of subsisting contracts. In relation to the entire contracts and termination, we referred the judge, amongst other things, to two cases I'll take you briefly to. Lusty, that's a decision of this court from 1991, volume 1 of the Authorities Bundle, tab 4. And this was a case of an architect providing services under a contract for development of a property which apart from an interim fee, he was going to be paid as a percentage of the construction works at 5%, I think, in that case. In the event the contract or the development was abandoned by the client, and a claim was made for payment for work done, which initially was put on the basis that it was work under a separate contract. That was rejected by the Court of Appeal, but they found that it was work done under the existing contract, which was an entire agreement, and that gave rise to a quantum merit claim. So the judgment of the court was given by Sir David Croom Johnson, starts at page 41. And page 48, the relevant passage, and in the middle of the main paragraph on that page, which has got the sidebar on it, there's a sentence saying, in my view, the first finding, that's of the judge below, was wrong. The work was carried out within the scope of the original contract. And then about 8 lines down, what happened in the case of Mr. Lusty was that when the defendants abandoned the whole idea of designing and putting up the office building, they deprived him of the opportunity of earning his fee under the contract of 2 April 1984.
Temporary, sorry, where are you?
Sorry, I'm on page 48.
Yes.
And I'm now sort of on the main paragraph on that page, which is runs towards the bottom of the page. There's a sentence starting, what happened in the case of Mr. Lusty?
Thank you.
So abandoned the whole idea of designing and putting up the office building, providing the opportunity of earning his fee under the contract. And then he refers to legal authority for this is Planche v. Coburn, summarised in Chitty at 2142 and over the page. You can see the citation. And that in fact follows the, I think word for word, the passage I took you to in Chitty earlier. And then the real position here after that citation was the plaintiff's right to earn 5% of the value of the works was taken away by the defendants. That necessarily included all the work up to getting commission. So on that basis that the claim was allowed, and that's an example of recovery on the grounds of unjust enrichment, where you have termination of an entire contract. The other case I wanted to take you to briefly is it is a brief decision of David Donaldson in Elec v Bartor. So that's at tab 12 in volume 1. And this is a jurisdiction challenge on the basis of no prospect of success of the claim, and the claim was put on the basis of a quantum merit for work done in relation to a joint venture where it had been contemplated that there would be a partnership at will created. Indeed, it was created, and the claimant argued that the partnership gave rise to an implied obligation of good faith, and that the breach of that entitled him to the value of all the work he'd done previously, and that was set aside, not least because the implied term was not laid out. And there is discussion in the judgment at, if I can pick it up, at firstly paragraph 8 on page 228. Simply noting there at the beginning of paragraph 8 on 228 that the only cause of action was quantum merit. The agreement created a partnership at will, like obligation of good faith, and gave rise to a quantum merit claim. And then at 12, the judge said, in the light of applicability, I've not posed a burden judgment with the survey and discussion of the material he'd been referred to. The proposition, third line, that following termination for repudiatory breach, an innocent contractor is entitled in lieu of damages to recover a quantum merit in his performance, can claim the support of a significant, if mainly elderly, body of English case law. Then he refers to Planchet, de Bernardi, Lodder and Lusty. He says critics suggest that Range of the Great Western is high-level authority to the contrary. He then says, I regard the rule as conceptually unsound and fertile with unattractive consequences. Doctrinal purity and logic does not always win out in the common law, but that will have to occur at a much higher level in the judicial hierarchy than I occupy. And then he says it's important to observe the limits of the rule in paragraph 13, addresses solely a situation in which, as a result of the wrongful termination or repudiation of the agreement, the claimant has failed to complete his contractual performance and is in consequence not reached a point where counter-performance by the defendant has become due, does not apply where the claimant has performed and has in consequence an entitlement under the contract to payment or remedy in damages. In that I agree with Mr. Justice Cook in Taylor v. Motability. So one can see there that he's acknowledging, at the very least, the existence of a body of case law, being the body of case law on which I rely, and which in my submission can be rationalised by reference to the modern authorities, most modern authorities on unjust enrichment. And he also explains the limits of of what was decided by Mr. Justice Cook in Taylor and Motability. given the time, I'm not going to take you to the High Court of Australia decision in Mann, which is quite a complicated case, but where both the reasoning of the majority, which is in two parts, and particularly the reasoning of the three of those judges in the majority is of assistance in really buttressing the points that I've made in relation to termination of an entire agreement. So just give me a moment. Maybe I could just pick up one passage from that judgment. So it is Mann and Peterson. You'll find it in the authorities bundle at tab 15. Case of termination of termination for repudiatory breach of the building contract. The builder claimed on a quantum merit for work done to the extent that the work had been done in relation to earlier stages of the contract for which there being divisible obligations. Payment had arisen under the contract, the claim failed, but the quantum merit claim was allowed by the majority in respect of work done subsequent to the last divisible stage, completed divisible stage of the contract. And I just want to pick up in the decision of three of the judges who formed the majority of four that upheld the claim, a passage which deals with restitution upon termination for breach. You'll find that in the judgments starting at page 375, and it's paragraph 164. So firstly, we get the distinction between what are called open contracts and discharge ones, and the explanation that position at law on contracts that are closed, including relevantly those terminated for repudiation, is different. And then at the next page, 166, as the law stands in Australia as it does in England, New Zealand, Canada and the United States, upon termination of the repudiation of an uncompleted contract containing an entire obligation for work and labour done the innocent party, the innocent party may sue either for damages for breach or it is option to restitution in respect to the value of the services provided. And then the availability of restitution, paragraph 167. And the form of remedy will depend on the type of enrichment which has been alleged. And then at 168 over the page, qualifying or vitiating factor giving rise to prima facie obligation as a total failure consideration or total failure of severable consideration. Then he explains what that means. State of affairs contemplated as the basis or reason for the payment. The relevant basis will be the benefit that's bargained for. In most cases, the test is whether or not the party claiming total failure has in fact received any part of the benefit bargained for under the contract or purported contract. More specifically, total failure consideration for work done exists by reason of the termination of a contract for breach, where the basis on which the work was done has failed to materialise or sustain itself, and the total failure consideration is seen as the occasion and part of the circumstances giving rise to the other party's obligation to make restitution to the extent of the fair value of the work. It's for that reason that no such obligation can arise while the obligation under which the benefit was conferred accepted remains open and capable of performance. Where next paragraph, where a contractor is only entitled to receive remuneration if the contract is wholly carried into effect and the other party's wrongful repudiation of the contract has the effect of preventing the contractor from becoming entitled to receive remuneration, the contractor may, after electing to treat the contract as an end, maintain an action to recover restitution as upon quantum merit for those services instead of suing for damages. And those are passages which I submit are reflective of the position under English law and which, in my submission, would undoubtedly apply in this case if this was a retainer which did not have any of the provisions of clause 14, and what one gets into a analysis of is whether clause 14 makes a difference in our case. So in terms of the, if I move from there to the judgment and our criticisms of the judgment, so back to Form 1 at tab 19. At page 192. So the consideration in relation to failure of basis starts at paragraph 41, and the judge really centres his discussion of the authorities on the subsisting contract cases rather than the cases, the other cases which I cited to him, to which I have taken you today in relation to contracts terminated for breach. And that underlies a lot of his thinking in relation to whether a claim is available in this case. So he starts off with discussion of Dargamo. And he draws, he makes reference at the bottom of page 192 and the top of page 193 to the uncontroversial statement that where the basis for consideration is expressly and unconditionally set out in the face of a valid and subsisting contract, there's no scope for inquiring into an alternative basis. Then he deals with the fact that matters are different when someone confers benefit without being obliged to do so under any contract. Here the obligation rule does not apply, and then says whether that is the case depends on a matter of construction, which is obviously correct. And Barton v Morris is a case which really turned on the construction of the agreement. And as he notes, and this is sort of coming into the silence point, which he then focuses on, he says in paragraph 44, Mr. Barton claimed an unjust enrichment containing a failure of basis. His claim succeeded in the Court of Appeals. The Court of Appeal held that the oral agreement was entirely silent as to what would happen if the sale completed. In other words, the contract said nothing about entitlement if the sale occurred at a lower price. And then he refers to Lady Rose in the Supreme Court, and one can see that from the passage cited there that silence of the contract as to what obligations arise on the happening of the particular event means that no obligations arise. This excludes not only an implied contractual contract, but a claim in unjust enrichment. And then he then says, Barton makes clear that silence is rarely a neutral factor. It often implies not a free-for-all, but a positive decision by the parties that certain performances done pursuant to the contract will not be rewarded. So let's just be clear what's being discussed here. This is a situation where, under a subsisting contract, performance is provided pursuant to the contract, and the contract does not address whether payment arises in return for that performance. And it's in those circumstances that the claim is examined and arises. In the context of a discharge contract, there's no doubt that the claim is the services are provided under the contract on the basis of the payment terms on completion of performance that are under that contract. But one is then considering in circumstances where there has been termination for repudiatory breach, and therefore, in that sense, the contract rendered ineffective, whether there is a total failure of a basis. So that's why I say one's looking at the question in a different way in the context of a subsisting contract, such as in Barton, and the case of a discharge contract for breach, as in our case, or as in Lusty, or as in Mann and Peterson. That's also reflective of the distinction that's made on the authorities as I've taken you through them, that generally where you've got a subsisting contract, it will be difficult to establish any claim for unjust enrichment, subject to the sort of exceptions that we have seen, as in Barnes, whilst in the case of a contract terminated for breach, failure for basis and lack of enforceability are, unenforceability because of a repudiatory breach are the same sides of the coin, to use Lord Justice Carr's terminology. So we then have the judge's reference to risk allocation. So he says in paragraph 47, following through this line on the subsisting contracts, that the approach could be reframed by reference to risk allocation, and he refers to Lord Justice Etherton as he then was in MacDonald. It's not obvious, but that is where it comes from, which was cited with approval in Barton at paragraph 47 at the bottom of this page 193. General rule to be upheld contractual arrangements by which parties have defined and allocated and restricted their mutual obligations, and that reflects a sound policy which acknowledges the parties' autonomy to configure the legal relations between them and provide certainty and limit disputes. So in the context of MacDonald, that was providing that the paying party was the company, not the owners of the land, and a quantum merit claim would upset that risk allocation. Another way of looking at it would be that the services were provided pursuant to a legal obligation under the contract, and that a quantum merit claim would seek to override the existence of that legal obligation. So the judge then says, At 49, the allocation of risk is therefore no more than the obligation rule discussed from a different standpoint. That may be the case, but again, just pausing, I took you to the passage at 33-012 in Goff and Jones in the supplement, which made the point that the obligation rule doesn't have operation in relation to other than in relation to subsisting contracts. And indeed, it's common ground, I think, in this case, that the obligation rule has no operation on the facts of our case. And then after there's a reference at paragraph 50 to photo productions and Securicor, and it's not entirely clear, as we've accepted in our skeleton, what the purpose of this reference was to photo productions and Securicor, to the extent that it was suggesting that, and this doesn't appear to be part of the judge's final reasoning, to the extent that it's suggesting that in circumstances where you terminate for repudiatory breach and a secondary obligation arises as a matter of law for payment of damages, that means you can't have a failure of basis or failure of consideration in a case of a contract terminated for repudiatory breach. That's just simply isn't correct. And indeed, if that were the case, then the authorities that
No, I think that what the judge is suggesting, then, what is important in the judge's reasoning is the last sentence of that paragraph, namely that the secondary obligations can be excluded or modified by the express words of the
Yes.
contract. And that's why he goes on to say there's no category difference, because he's saying the contract can govern what happens after acceptance of a repudiatory breach. I think that's all he's saying.
right.
So he's
Well,
saying
I
that
would-
he's saying that he just as what he's saying, as I understand it, is just as the contract can exclude a restitution and remedy while it is still on foot, so it can exclude a restitutionary remedy which is said to arise after it's been terminated by repudiation and acceptance.
Yes. Well, I mean, to the extent that he's saying that, that would be unexceptional, I think.
I think that's what
But
he's saying.
it doesn't mean that there's no category difference between unjust enrichment claims and claims where the contract is regularly performed. The approach in terms of analysis for, first of all, the application of the obligation rule is very different, as I have explained, and the approach to total failure basis is very different, because in one you have performed under a contract which remains in being, governs your rights and obligations, and in the other the contract has been brought to an end, and one's looking at whether service is provided on a basis that has, whether that service has been provided on a basis that has failed.
Mr. Scotty, how much longer do you think you're going to be? We
I'll
normally
probably
rise
go-
at 4:15, so if you're going to be 5 minutes, fine. If you're going to be longer, I think we'll resume tomorrow.
Well, look, I think if I will need about another at least 15 to 20 minutes, if not a
In
bit
that
more.
case, we will rise now and sit again tomorrow.
Thank you very much.